Hello, everybody, for joining us for this webinar today on how to hire employees in California. So my name is Galia Aharoni Schmidt. I am the owner and lawyer at Aharoni Business Law. We are a business law firm based out of Oakland, California. So we kind of help small businesses with everything they could possibly need other than going to court. So business law, employment law, and IP and trademarks especially is what we do. So we have been helping a lot of people with hiring employees, especially for the first time right now, which is awesome. And so I wanted to do this webinar today to help give people some information and see what they can do themselves and make sure they don't miss anything, because employment law is the kind of thing that is really easy to mess up by accident, and I don't want that to happen to you. I do need to say that this whole presentation is mostly about California law, some federal, but mostly California, which means I'm also assuming that all the workers we're talking about are in California. So you need to know that there might be city rules or county rules that are particular to you or your employee. The law usually depends on where the employee is, not where you are or where the business is. So do want to say that. And, again, the normal disclaimers of this isn't legal advice, and some rules are also different depending on how many employees you have. So I'll try to be as detailed as possible, but that's the kind of disclaimer. These rules are different depending on what your worker is doing, where they are, how many you have. So this is kind of a general overview. So people always ask, we will email the slides to you. They are available. And I tried to make these particularly detailed, actually, which is more than usual, because I want you to be able to use these slides as kind of a checklist if you want to. So they will be available. We'll send them to you. This program is different than our usual ones because it's really more focused on kind of the to-dos, like the step-by-step how-to, more so than what employment law is. So if you want to hear more about employment law, you can let us know. We can do another webinar, or you can contact us directly. And we have a bunch of articles and other videos on that stuff too, including stuff about handbooks if you have questions about that. But this is kind of going to be a really kind of step-by-step to-do list heavy how-to webinar. So as far as questions go, since we have a good handful of people, there's a lot of information today. So I'm going to do my best to be able to answer questions throughout and hopefully have time at the end too. But that said, if we run out of time or I don't get to your question for whatever reason, we will do our best to follow up with you directly via email. So the best way to get questions to me throughout this is to put it in the chat box. So you can either send it publicly or just to me. And if I have time, I will answer it during. If not, we'll follow up with you. Okay, so anytime throughout or at the end, send over questions in the chat box. Okay, and then from there, we're just gonna jump right in. So this is what we're gonna cover today. First, we're just going to do a couple of employment law basics, just things you need to know about employment law before hiring someone. We're going to talk about the recruiting and interviewing process. We're going to talk about all the paperwork you need to give someone or have them do when you're onboarding them. We're going to talk about the things you have to do about that employee right after hire. And then we're going to talk about ongoing obligations you have as an employer. So this is helpful, especially for your very first employee. But there are a lot of things that you have to do for every single employee. So I think even if you already have some employees, I hope this will still be helpful to you to make sure you're not missing anything, make sure you're complying with the rules every single time you hire someone new, okay? So let's jump in then. So again, this is going to be mostly a practical program, but there's a couple things you have to know before we dig in. So first of all, California is what they call an at-will employment state. So what that means is an employer can terminate an employee at any time for any reason or no reason, as long as the reason isn't unlawfully discriminatory. So that means you don't like the sound of someone's voice, totally fine. You can get rid of them, or you just get sick of them or whatever. That's fine. So this is the default in California. If you hire someone, the default is at will, but you can accidentally override at will employment and turn it into a contract position. So if it's a contract position, there's some sort of promise or contractual agreement that they're going to be working for you for a certain period of time. And it's much harder to get out of that relationship than an at will relationship. And so the risk of lawsuit is higher. So we can terminate anyone at any time as long as it isn't discriminatory. So what's discrimination then? Discrimination is that as the employer, you can't take any negative action against employees or applicants for jobs based on their membership in a protected class. So what's a protected class? These are most of them. So the ones on the left are the federal protected classes. The ones on the right are the ones that are in addition to those based on California law. So there are other laws that are tangentially related to this about things like not discriminating because of someone's natural hair or victims of domestic violence, or some rules in some areas about political affiliations. And several cities have their own laws for things like in San Francisco, for example, you can't discriminate against someone based on their height or weight, are considered protected classes. So this means we can fire anyone at any time if they're at will, unless it's because of their race or because of their religion or because of their sex, things like that. So discrimination is a theme of everything we're going to be talking about today. So that's why I wanted to start with this. Okay, so let's get to the practical stuff. Before you even hire someone, what are the things you need to know and you need to do? So this question comes up a lot when people are asking us about hiring employees for the first time. So how expensive is it to have an employee? So the general rule of thumb that people agree on is take whatever you're paying that person and add about 25 to 40% on top of what you're paying them. And that's how expensive they're going to be to you total. So it depends on things like what their job is and what benefits you're offering, which we'll get into. But generally, that's going to be including things like federal taxes, like Social Security, and then California taxes, like unemployment and disability. So as far as the taxes go, some of them are from the employee's pay, but some of them are paid by you. So it does increase your costs. You're required to have workers' compensation insurance, which we'll talk more about later, but that's an extra cost. And then there's just some mandatory benefits and leave and some optional ones that you can choose to have or not. And those things can cost money as well. And then there's just administrative costs like payroll costs. And what I mean by that is if you're paying for a service, or if you're providing PPEs like masks to people, or you're providing uniforms to people, all of those things cost money. So those are the things that make an employee more expensive. So the first question I always want people to ask is, do you even want employees? Is this worth it to you? And can you afford it? It's not just, minimum cost of minimum wage, it's the cost of their pay plus all of this on top of it. And it is, a lot of these are kind of a sunk cost. You do it for one person and then they leave and then you have to do it all over again. So it's not cheap. Before you're hiring your first person, there's kind of these 4 steps that happen. Number 1, the recruiting phase. Number 2, interviewing. Number 3, testing and background checks if you're doing that. And then number 4, the offer. So we'll go into each of these. So number 1 with recruiting is job descriptions. So job descriptions are optional, but they're very, very important. So the obvious reasons they're important are things like it's going to attract qualified people to the job, and it's going to make it easier to find someone who has the skill set you're looking for, and it sets expectations of what you're requiring them to do. But the part you might not think about is it actually helps protect you as the employer, because one thing you want to have in your job description is a description of the essential functions of the job. So this is the things that are required in order to get this job done. If someone can't perform the essential functions of the job, then it's okay not to hire them, even if they're in a protected class. So for example, if a job I'm hiring for requires that the person has to be able to lift 50 pounds, and I don't hire someone because they can't do that, then that's going to be evidence that it wasn't gender discrimination or disability discrimination. It was because this job requires someone to lift 50 pounds. And if you can't, then you can't. And so, so essential functions in your job description are key, and they protect you from lawsuits. That also is another reason to update the job description regularly if the job changes over time. People always forget to do that. So On the slides are things to include, essential functions, like I said, but good description of the job. Don't include anything that could possibly be construed as discriminatory. So again, the line is kind of fuzzy, and it's really important to be clear about things like essential functions. So you want to look for language that can be subtle but accidental and has led to lawsuits. So some examples. Digital native can be construed to be age discrimination because you're saying you're not going to hire someone who's older, right? You're only wanting to hire someone young. It has nothing to do with their skill set. Digital native suggests they're about age. And then there's also more generic terms that are just a little outdated and shouldn't be used because they include gender for no reason really, such as waitress or repairman. So you're going to want to use terms instead like restaurant server or a repair person. So it doesn't look like you're discriminating against a male server or a female repair person, for example. So look for things like that. You also want to be careful not to include anything that might be construed as creating a contract role. Again, so anything that kind of suggests that it might be a permanent position or for a certain period of time, anything like that, don't put it in there. So part 2, job applications. So job applications are not legally required, but they can be helpful. This is another long list of things not to include based in California law. So you can't ask any questions really that might cause them to give you information that you shouldn't be getting yet at this phase. So stuff about criminal history or salary, those are things that you're not allowed to ask yet in California anymore in the application phase. You're not allowed to require that they give you their social media info, stuff like that. You also should consider including things like an authorization to check references, and again, an at-will statement saying, I understand this is an at-will position, can't hurt. So if you get a generic job application online that you want to use, that's fine. A lot of people do that, but make sure that it's a California compliant one because we have a lot of rules that most other states don't have. So, and also check to see if your city or county has its own rules too. So if you're scared, you don't have to do applications. I don't actually do applications, but if you do, that's fine. Just make sure you're not asking about anything you're not allowed to. So second phase here is interviewing. So again, the main thing we want to be careful about is doing anything that might be construed as discriminatory. You know, why did you hire this person and not this other person? So use systems for this. So your interviews with different candidates are as similar as possible. Ideally, the same questions for everyone. If you want to have specific follow-up questions or things that, questions that about things that concern you about the resume, that's fine, but use some sort of form. And what I do internally is add number values to each kind of category of things we're looking for. So literally at the end, you just have a number spit out, this person's more qualified than that person. And that gives you an objective measure. So you're not accidentally, being swayed by your bias. It's a really good idea to have another person in on interviews with you. So you just have another witness there saying what happened. And again, just beware, it's really easy in interview settings to accidentally ask questions that you're not allowed to ask. So you're not allowed to ask things like marital status or, where country of origin. So if someone has an accent, you can't say, oh, where are you from? Or if they've got a wedding ring on, you can't say, oh, are you married? It's really easy to do that and you can't do that. So brush up on what you're allowed to ask or not in advance so you don't accidentally do something wrong. Number 3, testing and background checks. So references, first of all, I do think, it's totally okay to ask for references. It's best practice to get explicit permission from the candidate to call references. And also don't be surprised if you call and the only thing the reference says is, yeah, they worked here. Because a lot of people are scared of lawsuit. They're scared of being sued for saying something that's actionable. So it doesn't necessarily mean they're a bad candidate if they're not volunteering additional information other than they worked here. But do check references anyway. Testing. So by that, I mean any kind of tests you're giving someone before you hire them. So testing, again, our main thing is we have to be really careful about discrimination, even accidental. And we have to be really careful about not asking for information that we're not allowed to be asking for yet. So some tests are explicitly not okay. So one of them, for example, is the MMPI. It's a test you take at the psychologist or the psychiatrist that helps screen for mental illness. And I think it was Target, actually. Some really big company got in trouble for giving all of their employees the MMPI. And the reason they're not allowed to do that is because it's giving medical information that you're not allowed to be asking for yet. So stuff like that, definitely not okay. Some are probably okay. So things like a DISC profile or an Omnia profile that are really more about kind of personality traits, maybe okay, depending on the context and how you're using it and whether you have their permission. And also whether you're using it as as something you're basing your decision on, or just something to kind of get more information and come up with interview questions. And some are definitely okay. If I'm giving someone a grammar test who's going to be, filing for me, then that's totally fine. Grammar tests, writing tests, if they're related to the job, absolutely okay. So testing in general, though, is a very controversial topic right now, especially in California. It's different lawyers have different opinions on this. I think things like DISC are okay. Under certain situations, if you use it right. Some lawyers say, no, don't do it. It's not worth it. So decide what tests you want to do, figure out whether it has something to do with the job, and whether it's, think about whether you might accidentally be getting information about what classes they're in, protected classes, or private information like medical information you're not allowed to get. Okay. Drug tests. Oh, background checks next. So background checks, I'm talking about things like criminal background checks or credit checks. These are allowed technically in California, but there are lots of rules around how to do it, when to do it, the process, and what to do with the information you get. I think that generally background tests are not worth it unless there's a really good reason to do it. So for example, we hang on to a lot of client funds in our client trust account, and that's money that belongs to the client still and not to me. I'm just, in charge. I'm in charge of holding it. So if I am going to have an employee have access to this trust account, it might be a good reason to do a financial credit check on them to make sure that they, don't. Maybe they're going to be more at risk for mishandling client funds if their background check doesn't look good, or if someone's going to be working with small kids or really vulnerable groups. Maybe it's a good idea to do a criminal background check just to make sure there's nothing on their record that could jeopardize their ability to do the job well and legally. But generally, I think it's a bad idea to do them and not worth it unless there's a very specific reason, and unless the information you're getting from that background check is directly related to the job that they're doing, their ability to perform the job. So drug testing, I have a very similar answer to. So drug testing also is legal, but I again think you have to proceed with a lot of caution, especially now that weed is legal in California. So it makes it more complicated, right? So especially because it can stay in your system for weeks. So you give someone a drug test while they're applying for your job, comes back positive for pot. You don't know how long ago they smoked. It doesn't mean that they're smoking every day. It doesn't mean they're going to be high on the job. It doesn't really matter, right? So what I think is the right thing to do with drug testing is if there is an on-site or at work injury or accident or other incident that could be caused, that may have been caused by them being under the influence of drugs or alcohol, that's when you test. You test right away when it happens. Then you get information about whether they were under the influence of something when that thing happened. And it's also a really good idea to have written policies in general saying explicitly, even though alcohol is legal and even though pot is legal, you're not allowed to ever be under the influence at work, no matter what. So that's my advice. Again, other people think it's just fine to drug test everybody. So again, the thing is, make sure if you're testing people, there's a reason why you're testing some people and not other people. If you're not giving it to everybody, have a system so you're not accidentally discriminating. Okay, for all of these things, make sure whatever you're doing, it's the same for everyone. For the people who have been coming in, welcome. And just to repeat, since you missed it, if you have questions, feel free to send them in the chat box. I will try to answer them as I go or at the end. But if we don't get to it today, I will follow up over email later, or you'll also get my contact information at the end and you can contact us directly. Okay, the last step in the recruiting process is the offer. So you went through all this stuff, you found the perfect person, you want to hire them. So number one, first thing you want to do is put your offer in writing. And it should include, again, we want another at-will statement. Again, that just says, everyone understands that this is an at-will position, not a contract position. You want to put in terms of employment. So by that, I mean things like start date, whether they're exempt or not exempt, what their wages are going to be, if it's full-time or part-time, if there's any benefits they're getting, all of that stuff. And then you're going to want to put in any conditions that we were just talking about, like if there's drug testing involved or a criminal background check involved, if the employment is contingent on passing those things. And then you're going to want to say, you have to get back to me by X date. So you're not sitting around for weeks wondering where they're going. And then, so that's kind of the normal. 99% of all employees just do this offer letter with an at-will provision. There are some situations where an employment contract is appropriate. So an employment contract is usually used for higher level kind of management positions where it makes sense to give them extra terms or have them be employed for a set period of time. So if there's a reason to, then it might be helpful to have a written contract for that employment position. But otherwise, most of the time you won't need one. So don't worry too much about that, but there may be situations where it's relevant. All right, so we offered the job to our perfect person and they said yes. So what happens next? It's their first day at work and we are doing our onboarding meeting. And so these are all things, this is in checklist form. These are all the things that you're gonna do either at your first meeting, hopefully, or at least within the first few days. Okay, so the next few slides are going to look like this. This is all the paperwork you need to do right away. So on the left are all the forms that you need to do. On the right, we've got 3 columns. So prep, sign, and give. So prep means these are things that you have to do something to prepare that form before you give it to them at the meeting. So look at all those and put in your information, whatever it asks for before the meeting. Give just means you're required to give the new employee this thing. Sign means the employee is signing the thing and giving it to you. Okay, so that's what this all means. If there's a little asterisk by it, that means it's optional, but probably recommended. And if there's a little caret next to it, that means it's required if the situation calls for it. So I'll clarify those one by one, but that's the background here. Okay, so first thing, hiring checklist. This is just an internal checklist that we use, and we also help set up for our clients that just helps you remember to do all this stuff. So there are hiring checklists online if you want to find them. Make sure they're based in California law, or you can also just use these slides to make a hiring checklist of your own, but I think they're really handy so you don't accidentally forget something. By the way, one thing I forgot to mention is if your worker speaks primarily Spanish, all of these things are required to be in Spanish for them instead. Okay, number 1 is the I-9. We've all seen these. That's to verify that the worker is legally allowed to work in the United States, and it's verifying their ability to work in the United States. It is required that you give this to them within 3 days of their start of work. Okay, so that has been made more complicated during COVID and also just in general, because more and more workers are being hired remotely. So generally, if a worker is remote permanently, what you're supposed to do, you're not allowed to just have them hold it up to the webcam on Zoom. That's actually not allowed legally yet. So what you're supposed to do is have them go to an immigration specialist or another lawyer to verify in person, which is a pain. Temporarily, they have allowed everyone during COVID to do it remotely, where they hold up their stuff on Zoom or send it to you in advance online, and you have to mark on the I-9 that you're going to verify in person later when you can. But that's temporary. So if you can, do it in person if it makes sense. But it is your legal obligation to do this within 3 days. So in general, you do Section 2, employee does Section 1. The W-4 we've all seen too. That's just the piece of paper that the employee says what they want their federal tax withholdings to be. You have to give it to them. They will fill it out. So you know what taxes to take out. The DE-4 is the California version of that. So you are required to give it to them, but they are not required to fill that one out. They only have to do that one if they want anything other than the default California withholdings, which is pretty rare. Most people will choose their federal, but California is usually just default. But you have to give it to them. The 2810.5 notice, we've all seen these too. It's also called a, well, you've seen them before. It just kind of lays out the job, the details of the job, contact information, what the job is, part-time, wages, all of start date, things like that. But it is required, and it's better to fill that one out in advance of the meeting as well. Okay, the next one's here. You are required to give them a pamphlet about workers' comp called the time of hire pamphlet. So there is some prep work in there because you have to fill out some internal information about the workers' comp that you're providing them and give it to them. They can optionally fill it out with their doctor's information and give it to you, but they're not required to do so. Emergency contact info, that's just a sheet where you're asking them to give you information of their emergency contact if something goes wrong. So if they're working from home, maybe not such a big deal, but if they're working on site, especially if they're doing something dangerous, it's probably a good idea in case there's ever an accident on site or something happens to have that information. So optional to give them, optional to receive back, but highly recommended. Direct deposit authorization. This is a form that you give them where they give you authorization to put their pay directly into a bank account. So it's getting permission to do so, and it's also getting their pay and their bank account information. So if you are going to do direct deposit, if they're going to choose to do direct deposit, then you are required to get permission from them, but they are not required to do direct deposit actually. So if someone demands paper checks, you have to give them paper checks. I don't know anyone who demands paper checks, but some people are weird about banks, or I don't know. So you have to give them the option. But if you're doing direct deposit, you have to get permission and get their information. Okay. The next one is a harassment policy and a written lactation policy. So you're not required to have a full handbook, which we'll talk about, but you are required to at least have these policies in writing and give it to them. So you need to give it to them and you need to receive back a confirmation of receipt. And that's also, it's legally required, but it's also to help protect you. There's a new form that is required to give whether or not you give health insurance via, as a benefit. So you can look that up. And also if you get the slides later, these are all links to the forms that I'm talking about. So it's easier to find, but there's one version that you give if you don't give them health insurance. There's another version that you give if you do give them health insurance. So you're required to give one or the other depending on whether you do or not. If you do give health insurance as part of as a benefit, then you are required to give the notice of COBRA continuation coverage rights. If you don't give health insurance, you don't have to give that. This is just a list of brochures that you have to give them. So about disability, paid family leave, sexual harassment, and rights of victims of domestic violence. You just have to give, some of them are set forms, some of them there's samples online. And if you've written a job description, which I hope you have, that isn't also another good time to give it to them. So these are just things to give and they don't have to do anything. Again, if you're giving benefits like health insurance or retirement, 401k, anything like that, you're required to give them information about those benefits upfront. If you're doing a background check or a credit check, there is a bunch of information you're required to give them here. So those you're going to want to, you need to prep ahead of time, give them and have them sign. If they're working on commission, you have to have a written commission agreement. So same thing there. If they are a minor, there's a piece of paper that you're required to give and get signature. And if you have a handbook, again, so I'm talking about an employment handbook that, includes all of your employment policies. If you have one, give it to them then. And I recommend having a confirmation of receipt for them to sign as well to prove that they received it and that they read it. So that's all of the onboarding paperwork. So again, feel free to shoot over questions in the chat box in the meantime if you want to. But now we're going to jump to talking about, so now we've onboarded this person. What are the things that we need to do next after our first onboarding meeting? So these are things you need to do internally to be prepared to have your employees. So the first thing is to have a federal employer ID number, or FEIN. So an FEIN is basically like a business social security number or like tax ID number for your business federally. So many businesses are not required to have one upfront unless you have employees. So if you have employees or if you're a certain type of entity, you're going to be required to have these. And even if it's optional to have one, you can get one anyway. But bottom line is if you're going to have employees, you have to have one. So if you don't have one yet, get one now. The good part is you can do it online for free. It's super easy. It takes about 10 minutes. There's a link there, but if you just Google, get an EIN or do I need an EIN, it'll pop up and it's really easy to do. So the EIN is a one-time thing. You get one time. And it has to be on or before the first time you hire someone. So once you get it, you're good to go. It's the only time you need to get an EIN from then on, but it's stuck with you for the life of your business. So payroll is the next thing. You have to pay people, right? So payroll, there's a process involved. You have to make sure that people are being paid for all the work they do, right? For all the hours or that their salary is correct. There are things that you're required to track, like accrued sick time, which we'll talk about. And then also taxes. So the taxes that are coming out of their paycheck and also the taxes that you're paying. And then also you need to be tracking things like overtime. And so it's possible to run payroll manually, but it's super easy to mess up and it's complicated. So I think the easiest thing to do is to pay for a payroll system. So what I'm talking about is things like Paychex, Gusto, QuickBooks, systems that they're pretty cheap, but they're going to calculate taxes and accruals and stuff like that for you. So you're still required to put in information and to put in the hours everyone worked and all of that, but you don't have to do all the calculations and they're going to calculate all that stuff for you. So generally these cost about $35 to $60 a month base, and then another $4 to $8 a month on top of that per employee. So I pay about $75 a month for 6 employees, and it's totally worth it to me to not mess up my payroll. Another thing these payroll systems are going to do is California has a lot of requirements about what legally has to be on the employee's pay stubs. So these payroll systems are just going to automatically generate pay stubs that are compliant, and you don't have to worry about that either. So another way to do payroll is to outsource it. There are tons of companies that either just do payroll, or they do benefits in payroll, or accounting or bookkeeping firms that do payroll. So I have mine actually be done with my accountant, also does my books, also does my payroll, and it's great. And I just send the hours that everyone's worked and they do my payroll for me, and it's excellent. So that's even more hands-off, but obviously it's going to be more expensive. But if this is something that you just really have no interest in doing and are really afraid to mess up, it's not an unreasonable amount of cost usually to have someone do it for you. But those are kind of the main options you're looking at. So as far as how often you're supposed to pay, in California, most employees are required to be paid either every 2 weeks or twice a month. So there are some categories of people who are allowed to be paid once a month, but I wouldn't even worry about that. I think just the recommendation is to pay everyone every 2 weeks or twice a month, depending on how you want to do it. Inherent in this is that you have to have a timekeeping system. especially for if your workers are hourly. So it can be by hand on timesheets that they send you. But most companies are doing digital timekeeping now. We use one called Toggle. Another popular one is called T-Sheets, which apparently has been acquired by QuickBooks. So if you're doing QuickBooks Payroll, you can add on the T-Sheets timekeeping system as well to make it easy. There's a just ton of online options for this now, depending on what works for you. So again, the software setup is going to be a one-time thing, but every time you add a new employee, you're going to have to add them to your system, and you're going to have them set up by the end of the first pay cycle. So because of that, it often is easier to have their first day be at the beginning of a pay cycle, so you have days to get them all set up in the system before the next payday. It's not impossible, but difficult if they're doing one day of work before you have to run payroll for them. All right. Looks like we got some questions in too. So good question. Is there any point in saying that someone is on probation when they start? Pros and cons. So again, one of the things you have to be careful of is accidentally creating what seems like a contract position. So I generally recommend that people not say something like a probationary period or the common terms people use for that, because it sometimes can suggest that if they pass that period, they're guaranteed a job, or that they're guaranteed a job for 90 days, or that they're it's okay to have this kind of introductory period, but make sure there's no implication in there that if they pass it, they're definitely going to keep the job afterwards, because we want to keep it at will. So I believe I call mine an introductory period, but I have a statement in my handbook about it that says it doesn't guarantee continuing employment, blah, blah, blah. So because it's at will in California, there's not really a purpose, I think, in having an introductory period at all, because you can fire them anytime for any reason anyway. So it's up to you whether or not to do it. If you do, then I would say just be very, very clear that it's still at will and there's no guarantee of continuing employment. Okay, we're going to get to the other questions later. So thanks for sending them. All right, so the next one is registration with the EDD. So this is something you have to do for every single new employee, and you have to do it within 20 days of their first day of work. So the purpose of this is we're registering with the EDD so they know to take out state employment taxes. And it also tells the state that, if this person has creditors, or you have to pull out money for court-ordered child support, things like that. So that's the system for this. So if you want to do it by paper, there's a form, the DE-34, that just, you fill out their contact information and send it off. But you can also do it online. If you do it online, you just have to create an account. And then once you have an account, you can go in anytime and add your new. So that's what I do. It's pretty easy to do. So mandatory benefits. These are things that you have to give every employee no matter what. So the first is paid sick leave. So this is different from vacation or PTO. You are required in the state of California to give every employee at least 24 hours of paid sick leave per year. And it has to accrue at least 1 hour for every 30 hours worked. And that starts on their 90th day of employment. So those hours do roll over, but you can cap it per year at 48 hours a year. So one thing also to know is that some cities and counties like Oakland have their own rules that are even more strict about this. I believe LA does too. So again, this is one of those things you need to be familiar with your local laws of where the employee is, but you are required to do this. The good thing about a payroll system is that it'll automatically accrue this for you if you tell them what your policy is, but you're required to do it. So if you have 50 or more full-time equivalent employees, you're required to give health insurance. If you have fewer than that, you don't have to, but it's optional. There are some required leaves of absence that you have to give them. So Leave laws are very, very complicated, so I'm not going to get into it because it depends on how many employees you have, which ones apply. But things I'm talking about are things like family and medical leave. There's a bunch of kind of new COVID leaves that have just been created, pregnancy disability leave if someone's pregnant, and then just super random ones too that you might not even know about, like leave for donating an organ, leave for being on jury duty or being a witness to in a court proceeding, voting, a time off to vote, things like that. So most of these are unpaid leave, but you're required to give it to them. Workers' comp is the next one. So you're required to get workers' comp for every employee that you have. So and that does include remote employees, every employee. So there's a few different ways to get workers' comp. You can do it yourself directly through a popular one is called State Fund. I used to use State Fund. It's fairly reasonably priced. Workers' comp is not super expensive, but State Fund's pretty reasonably priced. I found that they were difficult to communicate with. And I switched. Now I have Gusto for payroll, and Gusto has a workers' comp add-on. So now it just comes straight out, which is really handy. Some people also go through a broker. So if you're working with a broker on anything else, it's an easy thing to do to also have a broker do workers' comp for you, but you're might be paying extra that way. So one thing to know about workers' comp, there's two different ways people set it up. One's like State Fund will come out. State Fund does it, I believe, annually. They would charge me. Based on how much I paid my people last year. They kind of estimate what it's going to be for the next year, and then we adjust it year by year if you overpaid or underpaid. Gusto takes it out per paycheck. So it's great because I'm only paying, $7 at a time or $15 at a time instead of $400 all at once. So I prefer that, but there's different ways to do it. So that's something to look at when you are shopping around for workers' comp. And again, to answer a question that came in, all of these rules basically that we're talking about today are about where the worker is, not where the employer is. So if you're in LA, but your employee is in Oakland, then the Oakland sick leave laws are the ones that apply, not the LA ones. All right, so there's also an endless list of optional benefits that we can offer, but don't have to. So things like paid vacation or PTO. So paid vacation is optional. You don't have to give it to people. Again, for optional benefits, you want to make sure if you're giving it to some people and not other people, there's a reason. So maybe you give paid vacation to full-time, but not to part-time, something like that, that's fine. But if you give it to one person and not another, you're going to need a good reason, a non-discriminatory reason to do so. So PTO also, you are allowed to have a system that's combined paid sick leave with vacation and call it PTO, as long as it still meets the minimum of the required sick leave time. So a lot of people are doing that, and that's fine. And you can, by the way, you don't have to accrue the paid sick leave or vacation. You can give it all at once if you want to, and then they just use it from there. A lot of people like doing that because you don't have to deal with the accrual stuff and keep track of everything. But as long as they're getting that minimum, you can do it however you want. Health and medical insurance, optional if you have fewer than 50, but it's a nice benefit to give people if you can. There are a lot of rules about it. So if you're going to do that, make sure you brush up. Similarly, if you want to give life insurance to people, that's great, or even things like disability insurance, retirement or 401k of some kind. All of those things are awesome to give. They're all optional. All of those do have extra regulations. So if you do want to give those, then talk to a lawyer or talk to a benefits specialist to make sure you're complying with all the rules. Okay. And then there's just other stuff that's totally optional, but can be really helpful to people, like childcare or transportation costs, wellness programs, education assistance, free lunches. But again, the main theme that you're probably sick of already me saying is make sure we're not being accidentally discriminatory. If we have some people coming into the office and they get free food, are we giving Are we giving something of equal value to remote workers, for example? It's not inherently discriminatory, but it might be construed that way. So be careful. So next, don't forget to just do all this other admin stuff when you hire someone new. So something like, if you have everyone have email addresses, set that up. Make sure they have access to all of the physical and digital spaces they need. Do they need a key to the office? Do they need access to the Google Drive or the Dropbox, whatever, wherever you keep your online stuff? I recommend having an internal list of all those things so you don't forget something and you could just do it all on the same day. You're going to also be responsible for providing office supplies, ergonomic equipment, safety equipment. And this one also applies for remote workers. If, I've got my little pad here with my wrist support, you're still responsible for people's ergonomic health and safety, even if they're working from home. So if they need a little wrist pad or they need a standing desk or a comfortable chair, then it's still your responsibility. Do you need to print business cards? Do you need to do new letterhead? Do you need to put them on the website? All of those things. So again, I recommend when you hire your first person, all of the things that come up that you need to do for them, put it in a list, and then that's your checklist for the next person. Okay. We've been getting a lot of questions about remote workers, and of course, a lot of people are working remotely now, and I think it's going to be here to stay for a lot of workers. So putting together this slide actually made me realize I should probably put together a whole webinar just on working with remote workers, but here's the short version, the short and dirty version. So again, generally, the law where the employee is the law that's governing the employment relationship. So if they're in the state of California and your business is in California, then again, all of the sick leave and the minimum wage and the everything from that city or county and their protected classes, those are all going to depend on where the person is. Make sure you know those rules. It's possible that if they have an office that's other than their home, and you're not using their home as a business address, it's possible you might have to get a local business license in the city where they're working. So let's say you get them a little office space somewhere. You might have to also register and get a local business license in that city too, because your business is doing business in that city. If they're just working from home and there's no kind of business presence in the state or in the county or city other than that, you probably don't have to, but that's a good question to check in with a lawyer about, just in case. If they're in another state entirely, same sort of issues, but even more complicated. So similarly, if you are an LLC or a corporation and the person is working out of an office space, you might have to register as a foreign entity in that other state. So for example, if I hire someone in Chicago and I get them an office space that they're required to work at, or even a PO box or something, I would probably have to register with the Illinois Secretary of State as a foreign entity, which is expensive and a pain in the butt. If they're just working from home and there's no physical presence in the state, you might not have to, but those rules are different per state. So again, that's a really good time to check with a professional, either a smart CPA or a lawyer would help figure that out, but it's something you need to be aware of if you're hiring out of state. And then we need to consider all the stuff we just talked about is now based on that other state's law. So even if my employee is working from home and I don't have to register as an out-of-state entity, I still have to register with the Illinois state as an employer. So Illinois state taxes can come out of that person's paycheck, just like my California taxes coming out of my California employees' paychecks. We need to make sure we're paying state taxes. Also, it's likely that your workers' comp will go way up if you're hiring out of state, because at least the way I understand it, because it's happened to me, let's say I'm paying $300 a year in California for workers' comp, probably 250 of that is just my basic standard fees that I have to pay for everything, and that extra $50 is what I'm actually paying per person. So if I'm hiring in a different state, I might now have to pay twice as much in workers' comp, even though it's just for one person. So beware of that too. If the person's worth it and they're awesome, then great. But if there's someone that you can hire in state, then that, it may or may not be worth it. And so it also might depend on how much you're paying them, whether it's, it's worth the cost or not. And again, compliance with other states' laws. So it's not just minimum wage and sick leave, but also things like mandatory harassment training, which we're going to talk about in a second. You're responsible for complying with all this other states' rules as well, and just figuring out what that even is, which can be a challenge. So I'm not saying never hire out of state, because I think it's, it's a whole new world in hiring now, where you can just reach so many more people, which is amazing. But know what you're getting into first, and make sure it's worth the extra pain in the butt and costs for you. Okay. Oh yeah. So I did want to say, if you are hiring out of state, you might want to consider clustering your hires in one or two other specific states then. So maybe I really like this person in Illinois, so I want to keep this person, but maybe my next hires are going to also be in Illinois or California, and so I don't have 5 different employees in 5 different states, but maybe I have 5 different employees in 2 different states. So some of the admin costs are not as burdensome, and tracking of laws and things like that. So just something to consider. Okay, I think I covered all that. So these are the things that you need to know and do permanently from now on. So we did all this stuff for the onboarding of this particular person, but what do we always have to do now? So if you have 5 or more employees, it's mandatory in California to do sexual harassment training. So this is required within 6 months of the start date of when the person started working, and then every 2 years after. So it's 1 hour every 2 years for regular employees, and it's 2 hours for supervisors. If your supervisor is out of state and they're supervising California workers, they also have to get this training. And other states, including Illinois, also have their own versions of harassment training required. So again, make sure you know, if you have workers out of state, this is one of the things to make sure you're complying with. For harassment training, there's, again, you can do it in-house if you want. You can hire a lawyer, an HR professional if you want, but there's a whole bunch of really cheap, approximately $20 to $25 per person online training that you can get. HR or Cal Chamber has one, I believe, is $25 per person, and it just does the training for you. It sends it to them over email. Again, that's one of those things that I think is the easiest and most cost-effective way to comply with this, but it is an expense. Employment posters. So we've all seen these too. So these are the ones, about minimum wage and workers' comp and pregnancy, just all of the things that are, many of these are required. There's federal posters, state posters, county and city. So it's going to be different which ones are required based on where you are and where your worker is. These posters often change every 6 to 12 months. So one thing I see people do a lot is their first hire, they do all their posters and then they never look at them again. And then 5 or 10 years goes by and all these posters are totally out of date and they're out of compliance with this law. So again, all of these posters are online for free somewhere. It's totally possible to find all the posters you need yourself, print them out, stick them up on the wall. But I also think that's a pain in the butt too. So if you don't want to spend that time, then again, places like Cal Chamber, but a bunch of other places have pre-made posters with all of the posters all put together. And a lot of them also have services that auto update. So every time there's a change in the posters that you're required to do, it just automatically ships you the updated poster. So if you're going to do that, which I think is a good idea, make sure we'll check whether they also have your city, your county and local too, because a lot of them will just have California and federal. There's going to be ones that are required for California and city too. So just some of them will have the city and county, some of them won't. So just check, make sure you have all the ones you need. posters are still required if people are working from home. So the way that that works is, so this is one of the things where the law hasn't really caught up with the way the world actually works, especially during COVID. So right now, so technically speaking, the law says that you're supposed to have physical copies sent to every employee. I think that is a little bit silly. So if you want to do strict reading of the rule, one thing you can do is just send a physical poster to every single employee. Especially, I think that's a safe thing to do if your workers are all permanent remote. If your workers are temporarily remote because of COVID, or they're just temporarily a couple days a week remote, then it's totally fine, in my opinion, to have them on a shared drive somewhere online. As long as the thing is easy for them to get to and they have access to it, I think it's totally fine to have all those posters in a Dropbox or something and everyone has access to it. Especially again, if it's temporary COVID, they're going to come back into a physical office later. So up to you how you want to do that. Again, best practice if you want is to send physical copies. If you are comfortable taking a not literal view of this law, I think digital copies are fine. But make sure no matter what, they're always up to date and make sure everybody always has access to them, okay? And again, that's based on where the worker is. So if you have a worker in LA and a worker in Oakland and a worker in Chicago, they're going to require different local posters. Okay, injury and illness prevention plan. This is one of the things that everybody's required to have and almost nobody does because nobody knows about it. So what this is a written document that lays out the rules about safety in your workplace. And so it's going to talk, depending on your workplace. So if it's an office, it's going to be things like ergonomics and not carrying things that are too heavy and not having things in the middle of the floor. If it's a warehouse, there's going to be things about lifting and safety procedures, things like that, or maybe working out in the heat so you don't get overheated, stuff like that. So it's going to really depend on your workplace, but you are required to have one if you have employees. So there are sample versions available on the Department of Labor website. So if you just Google sample injury and illness prevention plan, you'll find it. The problem with that one is it's very long and complicated and boring. So it can be hard for people to get through and hard for you to adapt. But if you don't want to hire a lawyer to do one for you, do that instead. That's a good place to go. Same exact thing right now. Everybody's required to have a COVID-19 prevention plan, which is basically a COVID version of your IIPP, injury and illness prevention plan. So the same thing, what are you doing to keep your workers safe from COVID-19? So masks and distancing and plexiglass barriers and staying home if you're sick, or all of those things that are about keeping your workers safe have to be written down. You have to have a written policy and nobody knows that yet. So same website, Department of Labor, they have a sample COVID-19 plan as well. At the very least, get that updated as much as you can. I know someone is about to ask, do you need to have these if you work from home, if your employees work from home too? Yes. And this is, again, one of those things that has not caught up with the real world. But one thing you need to know is even if your workers are working from home, you still can get in trouble for them getting hurt on the job. So there are cases, for example, even though it sounds crazy, a worker carrying something trips over their dog in their house and can get workers' comp. Or sue because of like an unsafe workplace. It's still, you have an obligation to make sure their workplace is safe. So it's still actually important to have these written policies. Some people do things like have a video inspection of the person's workspace. I personally don't. It's up to you whether you feel that's necessary. I just have internal policies that require certain things, and they promised me that they did do that, and we recertify that every year. And and they let me know if they need ergonomics or they need, you know, something that's going to make their workplace safer, if they need a desk or anything that's going to make their workplace safer. Okay. So the IAPPs are harder to do when people are working from home because a lot of the things in the sample one just doesn't really make sense if they're at home, but you still are required to have one. So make sure you do. Handbooks, again, optional, but heavily encouraged. And there are online resources to create a handbook. The one I recommend is, again, the Cal Chamber has a handbook creator. I think it's about $250. 100 times better to do that than to get one from someone or get it online, okay? But if you end up having a lot of employees, and by that I mean at least 5 to 15, it's probably a good idea to have a lawyer do it, because the one you're going to do online is just not going to be as tailored to you as your handbook should be. Handbook is both for the employee, but also for you to protect yourself from things like discrimination claims. So it's worth the expense once you have enough employees. You're required to give reimbursement for personal devices. So this is use of personal devices. So this is another thing that people never know. And it's really important to know when you have virtual remote workers. So if you're requiring someone to use their own laptop or their own phone for the job, which almost everybody does now, you're required to give them a reasonable reimbursement for the use of their thing, the use of their Wi-Fi, the use of their phone. The rules about what that means are not straightforward necessarily, but you can talk to an expert to figure it out. The main thing to know is that you have to give them some sort of reimbursement for their personal device use if it's required by the job. Reasonable accommodations if you have 5 or more employees. Again, if someone has some sort of disability, mental or physical, you're required in California to accommodate them within reason. So things like if an employee lets you know that they have a sensory processing disorder or ADHD, and they're really distracted by other people talking in their open workspace, you might need to get them things like noise canceling headphones, or, you know, put them somewhere quieter. And then obvious things like ramps if someone's in a wheelchair. So again, we want to update these things every 6 to 12 months. And you're just always going to want to brush up on things like wage laws, breaks, overtime, discrimination, harassment, things like that. So I know it's a lot. Remember, you don't have to do this stuff alone. You totally can. One of the reasons I wanted to do this presentation today was because most employees do this stuff on their own, and it's fine. But you know, there is always the risk of lawsuit. So if you want help with any of this stuff, my law firm can help. Other lawyers can help. We can help with, we do these things in packages. We do IIPPs, we do handbooks. We can help you fire someone if you ever need to do that. So if you ever want help with any of this, we are happy to be a resource. So we are out of time, and I don't like to go over. So here's my contact information. There were a few questions I didn't get to, and I apologize for that, but we will send the slides, so you'll have those, and you'll have the links that are included in the slides. And we will follow up directly with the people that we didn't get to today. Okay, so you'll hear from us, and you can also email us directly at the email address there. If you want to book a consultation with our office to get help with this or anything else, the link is there as well to automatically book an intake call with our office. So thank you all so much for being here with us today. I hope it was helpful. I wish you just the best of luck in hiring your new employees, and I hope it goes great for all of you. So thank you so much again for being here. Hope to be in touch again soon, and hope to see you at the next one. Have a great day, everybody. Thank you.